Any mention?
Please, Lordship, I beg to mention item number 12, Lordship.
Item number 12.
Item number 12.
Which the other side?
Is for state.
This matter is still pending before the Honorable Supreme Court. There's the issue of
Now it appears that there is a decision by a coordinated bench so far as this issue is concerned.
Lordship.
Now say supposing if Supreme Court decision comes and it says something otherwise than what has been said by this coordinated bench,
Lordship.
what this court can do in such a situation?
The order of the Supreme Court will prevail in that case.
But then can it ignore the order passed by coordinated bench by itself, or it has to be referred?
No, I don't think reference would be required. The order of the Supreme Court will prevail.
But then order of the coordinated bench also will remain.
It will remain for all subsequent cases. The order of the Honorable Supreme Court will prevail. That will be followed.
And what is your prayer now?
Lordship, matter may come up after 3 weeks.
Item 12.
12.
Yes, so on the joint request made by the parties, it is this matter after 3 weeks.
Highly.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 5, Your Lordship. I pray if this matter may be listed after 2 weeks, Your Lordship.
Item number 5.
Yes, Your Lordship.
Very fast item. Why? What is that case about?
My lord, this is that Cook matter, my lord. It had gone before the Honorable CJ, my lord. On the last occasion, they were supposed to produce the records. Because I had mentioned that my lord, regarding the trade test, that it could not have been conducted on the same day. So, my lord, therefore, the Honorable Chief Justice had, my lord, directed
Then there is no dispute to that.
produce
They
that.
admit to that, that test could not be held on that particular day and then your test was taken on some subsequent date. There is no dispute with regard to that.
My lord.
Then?
So, my lord, the
Anyway, but then why it has come back again then? Here.
my lord, subsequently may be transferred here, my lord.
What for? What is the reason?
That,
Is it that we change the roster?
maybe a new rooster, my lord. I'm not aware.
There's a change in the roster. So all the service matters will not be there. Okay. Yes. When do you want it?
2 weeks' time, Your Lordship.
For production of record?
Yes,
Or
Your
what?
Lordship.
Was
For
it
instruction,
that?
Your
Is it
Lordship.
That was on the last occasion.
The request made on behalf of Dr. N. Majwika, learned DSG appearing for the Union of India. This is matter after 2 weeks.
Highly obliged, Your Lordship.
All right, my lord.
Please, Your Lordship. Shall I beg to mention item 8, number 8?
Yes.
Number 8, 9 is. We need some accommodation in this matter, Lordship.
These are the matters where you say that.
Cantonment.
No, but then there was a submission that
No, that's
it
pending.
has to be taken over by or something.
Not
so-
yet, not yet. That this exercise of excision, that is still ongoing.
So now there is a prayer from the petitioner. You are from petitioner.
In item 8, Lordship.
And who
Mr. Sen is
Another
appearing for
petition, item number
9.
both are same?
Who is connected matters?
Who is the petitioner in item number 9?
And the petitioner. I'm appearing for the petition.
You also have the same prayer.
Same prayer.
Come on.
As for next after 2 weeks, it can be hard, I believe, Your Lordship, because
Sometimes second week of May. Manoj.
2 weeks.
In the meantime, we'll take an update with regard to that excision.
Yes. That is what you say, that abnormal enhancement of rent. Is it?
No, this
No,
is with
that
regard
is
to
demolition.
Demolition. Manoj.
demolition.
The allegation is that the buildings are unauthorized.
Okay, item 8 and 9. Just say. Write this. Lawyer's name. Plan comes to the petitioners. Praise for adjournment of the matter by 3 weeks. Mr. SP Manto, Senior Counsel. Applying for the respondent has no objection. Prayer allowed, released after 3 weeks.
Obliged.
May I please, Your Lordship? I beg to mention item number 6, Your Lordship. I pray this matter may come up after 3 weeks, Your Lordship.
Why? Why after 2 weeks?
Personal difficulty of the conducting counsel, Your Lordship. May I please, Your Lordship? Your Lordship, actually, this matter was listed before the Chief, Your Lordship. It's a service matter of 2018. It has come back to
This is a service matter.
Yes, Your Lordship, 2018 matter.
That is with regard to what? This is
Your Lordship, he was posted as an assistant lecturer.
what is
as
the
a-
cause of action? So far as this writ petition is concerned, what is the
Your Lordship, I am unable to hear you. I'm sorry.
who is appearing for the state here?
Mr. Kipi Bhattacharya, I'm also there, Your Lordship.
He was here just now. These are all, see, 18, 17 matters. Court is not very much inclined to grant time. Only in exceptional situation. These are unnecessary, these matters are remaining pending. When do you want it?
After 3 weeks, Your Lordship. Objection, Your Lordship.
Say, item 6 on the prayer made on behalf of the petitioner, this is matter after 2 weeks.
Highly obliged, Your Lordship. Obliged, Lordship.
Lordship, I beg to mention item number 18 in the main list, Happy Stone. Lordship, I beg to pray that this matter may come up after 3 weeks.
You are making mention on behalf of the state.
Yes, Lordship.
You are also there.
Your Lordship, items 18, 19 and 20 are connected. I'm appearing on behalf of Mr. N. Sinkon on items 19 and 20.
18, 19, these are connected matters.
Lordship.
Arising out of the same case.
Yes,
Yes, Your Lordship.
And you are appearing for?
On behalf of Mr. N. Sinkon, Your Lordship, for the state.
Mr. Sinkon is also a state counsel.
Yes, Your Lordship.
And then you are making, Mr. Thava, you are making mention for?
For item number 18, Lordship,
On behalf of?
on behalf of Sir Argrim. State, on behalf of State, Lordship.
You said Mr. Sinkon is there.
Your Lordship, in items 19 and 20, he's there.
You are the petitioner.
Yes, Your Lordship.
No objection.
No objection, Your Lordship.
18, 19, just say, on the request made on behalf of the state respondents. This matter after 2 weeks.
Obliged, Your Lordship.
Obliged.
May it please, Your Lordship. Your Lordship, item number 13, Your Lordship.
Yes.
Item number 13 till 16, Your Lordship.
13 to?
16, Your Lordship. 17, Your Lordship.
Yes.
Your Lordship, I may be allowed to withdraw this petition, Your Lordship, with the liberty to file a fresh.
Have some reservation, Your Lordship. What should happen after going through the statement, the deposition of the survivor, Your Lordship? Nothing has been said about the compromise. So it appears, Your Lordship, that I would pray, Your Lordship, that 340 CRPC mechanism be invoked.
Lordship.
We will allow you to withdraw, but then we will not give you liberty.
Lordship.
If you want to ask for liberty, then you have to satisfy the court what is the defect in the petition.
Lordship, then I may be allowed to withdraw then, Your Lordship.
You just
I have some reservation, Your Lordship, because in the deposition made by the survivor, Your Lordship, before the learned trial court, Your Lordship, nothing has been said about the compromise, Your Lordship, about that deed of settlement which
Mr.
they
Shulai,
have,
let them, since they are withdrawing,
Lordship,
if they are
because
insisting, then okay, maybe.
if 340 CRPC is invoked, Your Lordship, because 181 IPC, Your Lordship, will be attracted.
Perjury.
Lordship, yes, certainly. Kindly have a look at 181, Your Lordship, IPC. Before that, Your Lordship, if Lordship is pleased to see 340.
This could understand, but then since they are, we will not give them any liberty. Let it be. We don't. You take into consideration the many things may happen. You see, like we do not know the background of those parties.
It appears, Your Lordship,
What role a lawyer plays also, so everything.
because
comes
if
into
that statement, because it's a statement on oath, Your Lordship, before the
sometimes
trial
things may
court.
become very unpleasant also. So I think since they are withdrawing without anything,
So, Your Lordship, if that is a clear case of, it's a clear case of perjury, Your Lordship.
besides, that is the reason. That is why you see. Yeah. Anyway, just I think 13, 14, 15, 16, 17, all those matters. Ms. So-and-so, London Council, appearing for the petitioner, prays that the petitioner may be allowed to withdraw this petition. So, in view of the submission, this petition is dismissed on withdrawal.
Obliged, Your Lordship.
In this same order will be then 13 to 17.
13 to 17.
This is the name of the parties. You are there.
I beg to mention item number 10.
Item number 10.
Yes, Your Lordship. I'm praying for 2 weeks time, Your Lordship.
Yes. You are appearing for, you are mention for
State respondent, Your Lordship.
state respondent.
Yes, Your Lordship.
Yes.
Lordship, they have informed us yesterday that they are going
So
to
you are not
take
objecting.
time.
You are not objecting to their prayer.
No, Lordship, I am not objecting.
2 weeks time, Your Lordship.
When you want it.
After 2 weeks, Your Lordship.
Say 10 on the request made on the state respondent. List after 2 weeks. Okay.
Obliged, Your Lordship.
Lordship, obliged.
You know, if asked the part 1 matters, the orders, then you understand.
Daily cause list, item number 1.
May it please your lordship.
Yes.
Lordship, in this matter we were supposed to file our affidavit, your lordship.
On behalf
Lordship,
of
due to
respondent
some
number
9 to 11, your lordship.
So what
Due to
happened?
some difficulty, your lordship, we couldn't file it.
This is a 22 matter. 22.
I humbly pray some more time may be given, your lordship.
Yeah.
No objection.
Yes, sir. Ms. So-and-so, appearing on
2
behalf
weeks,
of
your lordship.
appearing on behalf of the. You are appearing for all the respondents.
9 to 11, your lordship.
No, and who are representing the other respondents?
For other respondents also.
They're appearing
Same
for
concept.
same respondents.
Same concept.
So-and-so appearing for the respondents, please for further 2 weeks time for filing a counter affidavit on behalf of respondent number 9 to 11. Stop. The prayer has not been opposed by London Council for the petitioner. Prayer allowed, list after 2 weeks.
Yes, your lordship. Highly obliged, your lordship.
Item number 2.
I may please your lordship. Lordship, in this matter we have been.
One second, Mr. The, this matter will come up for motion, huh?
Yes, my lord.
Kindly make it listed for motion. The last matter. No notice has been issued. This is matter of 2 weeks for motion. Or in the for motion. That's better. Please inform the others.
Yes, my lord. I will inform.
Yes.
Lordship, as per the order dated 2nd April, Lordship, we have been allowed to take step even by justice service. Accordingly, your lordship, the notice has been served to the accused, your lordship, the sole respondent herein.
But then it was supposed to be done in addition to the usual process.
Lordship, yes.
So you have not taken steps by usual process.
That's the we have taken through dust.
That is okay, but then see, usual process is also required. If court order is there, that has to be complied with.
We'll take step accordingly, your lordship. We'll file an affidavit also to that effect, your lordship.
As per order dated 2/4/2024, the petitioner was supposed to take steps for service of notice upon the sole respondent by justice service in addition to the usual process of service. Mr. Additional AG submits that step for service of notice by justice service has already been taken.
Has been effected, your lordship.
It already been taken, and the respondent has already received the notice. Step, however, there is nothing on record that step for service by usual process was taken by the petitioner. Step, since it was a requirement, the petitioner shall also take step for service upon the sole respondent by usual process of service within a period of 2 weeks. Where you have ended these things, where you see it, like additionally submitted, just after full stop you say none appears for the respondent when the matter none appears for the respondent. Then what is what is it? The next line. Oh, this however you can say that however you add to the previous line. However, none appears. Okay, and you cancel it there.
Apply.
Take steps within 2 weeks.
Lordship will take step, then at the same time we'll file the affidavit, your lordship, regarding the.
This is matter after 2 weeks. Then the last time.
Apply, your lordship.
Supplementary causeless, item number 1.
Yes.
May I please, Lordship?
Where is
Lordship, the
Mr.
conducting
Gautam?
counsel is on Lex, Your Lordship.
See, Mr.
Appeal
Sen,
the matter will take an
though
attendance.
there is a submission. Yesterday, Mr. Gautam has made a submission saying that this evidence was submitted by you of an affidavit. But then his statement made in the petition is totally different. See paragraph 5. Now, this is a problem, you see. If it is statement of fact and if it is supported by affidavit, see paragraph 5 of the petition. This code basically places all the reliance on the lawyers appearing. See, there is a statement made after recording the statement.
Lordship says that.
Then?
I think it's an omission on their part.
But then that has to be corrected then. It's a statement on oath.
Correct. Not true.
Or there has to be a statement at the bar saying that this is a wrong statement.
Not true.
So until unless this is made, how this court will proceed?
Not true.
Because
I'll just convey this to him.
This will have a bearing on the merit of the matter.
Correct.
Because two aspects. then matter will not be confined only to 202.
Lordship.
You have to see 200 also.
Yes, yes.
This in your petition in paragraph 5, the petitioner submits the court of also after being made and after recording the statement of the complaint. But your argument is
How do you reconcile? You made a statement submission, you made a submission and your statement supported by.
Lordship, my lord, that particular plea, my lord, recording the statement, my lord, basically what meant, according to me, was, my lord, the magistrate recorded the statement, but my lord, actually it was taken on affidavit. So, my lord, it was, my lord, that it's a wrong choice of words, perhaps, my lord. But otherwise, my lord, what I meant is, my lord, the matter,
No, if you say that this evidence was submitted by your affidavit, that means the affidavit is shown in somewhere else and it is submitted to the court, like what is done in the civil matter.
My lord. Well, that is a mistake on my part, my lord. I do agree.
But then you should have pointed out. You see, like this is something you have not pointed out. This court simply relied on the whatever you have said. And now your paragraph number 5 is very much specific.
The recording of the statement of the complaint, my lord, basically what I meant by that also, my lord. If it is constituted in that particular way, recording of the statement on the basis of an affidavit, my lord. Not recording by that, I do not mean that the
But then your
complaint.
paragraph 5 is something different. Paragraph 5 specifically says the petitioner submits that the Court of Judicial Minute First Class Shillong after motion being made and after recording the statement of the complainant past order.
So, my lord,
what does it mean?
My lord, a date was fixed for recording of the statement. However, affidavit was submitted on the basis of that.
But then you
process
say
was
that
served.
is recorded. So are you disputing the very statement made with this thing? If
No,
you
my
say
lord,
that,
that
then
is-
we will record it. There is no problem for the court to come
No,
to
my
a
lord,
finding.
what I am saying is, my lord, while drafting the matter, my lord, perhaps we made a mistake. By saying recording, we do not mean that the person stood in the dock on solemn affirmation, the statement was recorded and the process was issued. What I am saying is that
But then
on the
there is
basis
no
of an
such- no
affidavit,
such explanation here.
my lord,
See,
lordship.
two statements cannot go together.
Absolutely correct, my lord. I
So
do
one
understand.
has to be correct. So then you have to say that there is a mistake in paragraph 5.
Well, there apparently is a mistake, my lord. I apologize for that, my lord.
You should have said it.
Well, while arguing, my lord, I did not go through that
Because
particular.
once you file a petition supported by an affidavit, this court cannot ignore those.
My lord, lordship.
So until and unless there is a statement by you,
Apparently,
that
my
the
lord, there is a
statement
mistake.
appears to be some mistake and all, this court cannot draw its own conclusion saying that there is a mistake.
But my lord, what I'm
That is
saying.
what the problem is.
Lordship.
Plus, it will have effect on your arguments also. You see, what revealed from your argument yesterday is that violation of 202.
202.
And then you said that there is no ingredients for.
My lord, on merits.
These are this.
Just two things, my lord.
But then, if here it comes to that evidence statement was not recorded by the thing, then comes violation of 200 also comes.
Absolutely, my lord.
Then Mr. Sen first will have to come across the hurdle of section 200, then come to 202.
Lordship.
202 will come at a subsequent stage.
Subsequently.
First,
After
you will
he-
be satisfied. Now, what happens? So, at least one thing is correct, that you are not disputing that Mr. Sen that this evidence was submitted by an affidavit.
Yes, my lords, I'm
So
not
there is
disputing.
no recording statement.
Lordship.
So 200, there is apparently violation of section 200.
200.
Now, what is the consequence of that? Just leave aside this 202
Lordship.
for the time being.
But that is what I was referring to the judgment of Rupa and Bhattacharjee yesterday. If Lordship, can you have that?
That there is a
was-
remand. There is a remand of the matter.
Yes, so there again, my lords, what had happened, apart from challenging the maintainability of the issue, they had one of the issues raised in the CRP was that the statement of the
But then you were
complainant was
disputing
recorded.
the proposition laid down in that decision. You were saying that you are not in agreement.
They did
with
not,
that.
well, so respectfully, I would say the court did
No,
not
definitely that
advert
is-
to 465.
Our difference is always respectful.
With great respect, maybe that is my understanding. I may be completely wrong. That 465 was not examined. But what has happened here again, they did not set aside the entire proceedings. They did not quash the proceedings. They remanded it back, and the direction was that all orders and even the affidavit should be discarded. It should be completely disregarded, and the court should resort to 200 and record the statement of the complainant first. in
You see,
accordance.
your reference to section 465, I think it is correct. It was correct. Yesterday, though initially the court was of the opinion that this will
I was
come
just telling
into
my
this.
friend that outside.
But then may not be strictly come to 462, but then 461 will to come into play.
Lordship.
See, until and unless a defect vitiates a trial,
Lordship. There has to be a very
that
serious
can be
miscarriage of
treated as
justice.
irregular. See,
Lordship.
so now the matter now confines 202 as we understand there remains no defect is view of the effects to judgment, the matter will go back. But then what is the consequence of non-adherence to section 200?
So, my lords,
As you
that
say,
can
that
be
is
treated
one.
as irregular. And I have no difficulty, even if lordships go by the judgment in Rupa and Bhattacharjee, adopt the same reasoning and come to the conclusion or direct the trial court to discard the
What
affidavit.
happens if court doesn't go by the proposition laid down in Rupa and Bhattacharjee's case?
So I had even conceded as far as this statement is concerned. My first submission, my first leg of submission is that, my lords, mere filing of an affidavit does not completely vitiate the entire proceeding till today's, till whatever extent the proceeding has proceeded this
See,
far.
one thing is that when court issues process,
My lord,
that means section 204 comes into play.
lordship.
The very issuance is process. It is not covered by 200, 202, 203 and all.
Lordship.
203, when court after 200 decides there is no case, okay, decides not to proceed. 203 comes. So once matter ends at the stage of 200, then there is no question of adherence to 202 and other things.
Lordship.
Now here it's a case where process was issued. It means 204.
Lordship.
Now 204 mandates that the court must record a prima facie satisfaction.
Lordship.
Not in detail order, but then court must say it.
Lordship.
Now you will find there are many judgments by apex court where for non-adherence of 204 matter has been quashed. There is a
Correct.
recent judgment also.
Lordship. The satisfaction is not recorded. Correct.
Now the same thing remains when it's a case of non-examination. Because satisfaction apparently is not there.
Should be based on that.
Yes.
Should be
See,
based on
when
that.
202 comes into play, then satisfaction has to be based on the investigation conducted either by the court or by the police.
Lordship. So
But
the
then
only
here
issues
it's
now.
admittedly nothing has been done.
My lord.
Now, as there is no dispute between the parties with regard to the submission of the statement by way of affidavit, that means there is an utter this thing, non-adherence.
Lordship.
And even 204 also has been violated. But will it not result?
There
in
was no
quashing?
reasoning assigned. Yes. I'm not disputing that, my lords.
No,
So,
then can't we say
Lordship.
that 204 also has been violated? And then in such a case, your judgment
Lordship.
may not, you see, it may apply to the extent, but then when 202 has not been applied, that judgment may not be applicable.
So, my lords, there are three stages, I understand correctly. For 200, the statement has to be recorded. Our dispute here is with regard to the manner in which the statement should be recorded. Should it be physically recorded or an affidavit would be sufficient? Number one. Second stage is 202, where if the court finds that the accused does not reside within the jurisdiction of the court will resort to an inquiry in whichever mode, either by
Second stage is 202,
202.
when court decides to proceed after 200.
Correct. After
Otherwise,
recording the
it will
statement.
end, a court will adopt 203 and will dismiss. Will not come to 202.
No, what I'm saying, if
See,
we.
why your statement becomes important?
Lordship.
It may happen like that. The court records the statement and finds there is nothing.
Correct.
In
correct.
such a case, court doesn't have to go to 202.
No, I understand completely. I'm just saying in a situation
By
where the court.
resorting to 203, court will dismiss the matter.
Lordship, I'm saying in a situation where the court wants to proceed further, then the court comes to 202 and then referring to the proviso because the respondent, the accused, does not reside within its jurisdiction, directs an inquiry. So there are two sets of materials before the court. One is the complaint and the statement. Then thereafter the inquiry report, in whichever manner the inquiry is conducted. Then the court has to again assign reasons recording its subjective satisfaction. That I am satisfied that there is sufficient ground for proceeding in the matter. And then it issues process. That is the language of 202 as well.
Now, when there is non-adherence to 204,
Lordship, where the court has not recorded reasons.
when 204 comes into operation, when court decides to issue process.
Lordship.
So your matter, the present matter here, 200, 202 and 204.
Yes.
All process have been, or all provisions
There has
have been
not been any
tasked.
adherence to
all
that.
provisions have been tasked by the act of the court. Now,
Lordship.
whether it was done rightly or wrongly, that is the issue.
Lordship.
Now, as you say, maybe 200 or 202 violation may not result in quashing of the
Lordship.
proceeding.
Lordship.
Irregularity can be sent back, it can be corrected. What about 204?
But same submission, my lord. Because ultimately the
But then
litigant cannot
there
suffer for this, my lord.
There are many decisions by the apex court of the recent years. 204, not there, has been quashed.
Let me examine that, my lord, then in that case.
Now,
Because I'll have to see the facts as well.
Yesterday, after hearing in the things, this court was of the opinion that can be disposed of. Now, this statement, paragraph number 5,
Lordship.
has changed the whole entire perception. Because it was required for this court to ascertain whether there, because it will have a far-reaching bearing. Please examine in that part, though Mr. Gautam has not raised that 204 plea. But then since probably this court has come back to certain decisions.
I understand.
So,
My lord, I may be allowed to plea. My lord, the reason why I have not gone through that is because, my lord, both of us came to a particular understanding that since there is non-adherence of 202, the matter can be sent back. And Lordship was also on that particular
no, but then see, 204 comes into play.
My lord, exactly.
And what can we see? 200 also, I think that is also, it's corrigible. It can be corrected. You see, this is an irregularity.
But
So that also may not result in. But then, can we at this stage say that there is non-adherence to 204 also?
Because yesterday Lordship had raised a query that if this issuance of process goes, whether Lordship can quash the entire
So
proceedings.
if Lordships are looking at 202 and 200 and 202 already, then the requirement of looking at 204 may not arise.
No,
That's
my
my
lord,
humble
That
submission.
is where
But
so
my
if you
submission
can
is a little different.
place something, you don't know since this question has come, or otherwise, if you want that this court to pass some order on the basis of whatever argument you've made, that also this court.
No, but if Lordships are also going to look at 204, then kindly give me some time because I'll have to examine the facts in those cases.
Don't you think it will be appropriate, or you say like we do not have to look at 204?
But that will depend on the petitioner.
Once process is issued, you cannot say that 204 has not come into operation.
No, why I'm saying this, my lords, because like Lordships have observed, there are different stages. 200 is the first stage, then 202 and then 204.
That is the
If the
understanding-
first two stages...
That is the understanding of the court. It may be erroneous.
No, I don't think that is wrong. I would agree, my lords. So if 200 and 202 itself there is a non-compliance and Lordships are seeking to interfere at that stage, the question of looking at 204 may not be necessary. 204, perhaps in those cases that Lordships are referring to, in those cases where the court examined 204, the context perhaps may have been that 200 and 202 was not a question in those cases. There was no violation or non-compliance of 200 and 202. But here, at the very initial stage, when the court took up the matter, there seems to have been a non-adherence to 200 and 202. So Lordships will just confine, perhaps, I'm just saying this, my lords, to only look at those two issues. And if Lordships find there is a fault there, then the question of looking at 204 may not be necessary.
But then when it comes to 204,
Lordship.
whether there is an issue of 200 or 202, which way it makes a difference. Ultimate thing is that before issuance of process, court must come to a conclusion that there is a there are primary materials to proceed with.
Yes, but my lord, that would, in my humble submission, that was the merit of the matter.
The query which this court is putting to you is that, say, non-examination of complainant, that means there is no material available before the court.
Lordship.
So what is the basis of issuance of process?
No, it's not exactly non-examination in that sense. An affidavit was there. So court treated that as the statement of the...
Could not have been, if it is irregular practice, then court could not have based anything on that.
Correct. But I'm just saying in this particular case, the court has based, looked at the statement on the basis of the affidavit which was filed. So that
matter has become quite interesting.
So that practice I'm considering may not be correct. Number one. Number two is 202, where the court finds, because the court will derive jurisdiction only after there is a report, the investigation report. That report was not before the court. So it immediately attacks the initial jurisdiction of the court. That is why I'm saying, therefore, 204 may not be necessary to look at.
But the issue of process under what?
Under 204. So I'm saying...
Rightly or wrongly, process has been issued in this matter.
Yes. So if Lordships interfere on 202...
The court judgment has nothing so far as 204 is concerned.
Yes, it does not have anything.
So that is what. Now, is it not that we come to a new arena or we'll end up in some other area?
Then I have to just examine whether there are case laws where all three issues have been examined by the court.
Yes, that would be, if we can get certain things, this will be of much help. Or otherwise, court will have to draw its own conclusion depending on.
But then Lordships allow us to assist, my lord, in this issue.
Court found it to be quite interesting.
Yes, yes,
and the thought was basically came from the perusal of paragraph 5. So
my mistake is.
You should have, definitely.
No, actually,
you see one thing, Mr. Kish, this court blindly goes by whatever the council says. Sometimes what happened, you understand that because I was
my lord,
the other side.
Totally understand.
So has a blind faith on whatever you say so far as the factual aspect is concerned. So I would definitely expect lawyers to be very fair so far as the facts are concerned.
My lord, this thing, my lord, the reason why it is mentioned as recording of statement is there, my lord, is on the basis of
And
this
see,
order.
it is not the mistake is only here. Come to your synopsis.
My lord.
Same literation.
My lord, when I say
See, it is not that this court was not trying to verify it, right? And you have made this court to go through the entire petition from page 1 to last page.
My lord, yesterday, my lord, I really apologize because of that mistake which I have made, my lord, but on both of us agree that, my lord, there is an affidavit there, my lord, so we are not in a way trying to mislead the court. Perhaps there has been a mistake in drafting the petition. But, my lord, yesterday the reason why I did not come to 204 is because, my lord, after the hearing, lordship had put a query. Now, if the process goes, if cognizance has not been taken, whether your honor, lordship can hear the case on the merit of the case or not. So, my lord, I have
No, for 204 you do not have to go to the merit.
So, my lord, because
what was required, point out, the order passed by the trial court.
It's not
and to
not
show
speaking order.
that no satisfaction was recorded.
Nothing was there. No prima facie satisfaction was recorded.
Now, what is the basis of issuing satisfaction? We will not go into it. So, merit at all is not required.
Lordship. So, what Lordship is saying, I understand, my lord. The court, on what basis did the court issue process without recording prima facie satisfaction? On the basis of the complaint as well as
that is what the understanding. You see, the normal understanding. If you see,
Lordship,
if you follow the sequence or the manner in which a criminal complaint case should proceed. So this is the thing. First take 200.
200.
Then if it is outstation accused, 202. Or if matter gets dismissed or rejected at the stage of 200, 200 by resorting to 3 gone. Or if 200 and 202 is complied with, then comes 204.
204.
Now, but then once you issue process, because under 202 or 200, court has no power to issue process. So, moment process is issued, it means 204 has been made operational.
Right.
Now, that is the case in here, we can say that 200 has been touched, 202 has been touched, and 204 has been touched. Now, yesterday, we can say that our interaction or your argument was confined to till 202. We did not come to 204.
Lordship.
Now, today we are coming to new phase.
No, I understand. And also, Bank of Oman doesn't deal with 204. There is no discussion whether the court had expressed any reasoning.
Because if you see, there are certain decisions, though only on 204.
Lordship.
It says non-adherence 204 washed.
But that perhaps in those the
fact,
background is
this court in some other judgments has followed those decisions of that.
Lordship.
There are probably in 2022, 23, 22 you will find.
Lordship.
There are decisions. One by Justice Gawai, when chatted by Justice Gawai also is there. That reiterated that old same provision. That it's must. Because issuer's process is not a minor thing.
Yes, yes.
Once a person is made to appear before the court, that affects his standing in the society.
Correct.
So these are the things which
Lordship.
should be taken into consideration.
Grant us a little bit of time to
the court
assist
is
my
not
lords on this issue.
against that. It is for you to say. If you want time, we'll give time. If you want that,
I will assist Lordship. That
will
204 is also concerned.
Kindly, when shall we get it listed?
It's in the second week of May.
Oh, you'll be outside.
I'll be on session.
Well, now again, though, we do not know that track will get lost. You see, like where we are.
We'll summarize. We'll summarize for lordships and.
Because in between, you see, like you do not know, but then again, you may have to refresh the court about those things.
So would lordships then prefer to have it tomorrow?
Kindly take a note of those things. What
can we have?
Whatever.
If lordship would prefer to have it tomorrow, I'll try and see what. I'll do some research on that.
We have another part matter,
Lordship,
which was criminal appeal, which is a criminal appeal. It's listed
taken up yesterday. The one which was taken up yesterday.
Yes. So I do not know.
Right.
Anyway, we'll have it. Just make sure that you just refresh the code.
Yes, Lord.
In case this code forgets. Okay. Just say on the joint request made by the parties. Release this matter after 3 weeks.
Highly obliged.
Much obliged.
Interesting.
Well, I apologize once again. Well, that did not cross my mind.
No, it's all right. But then there should not be any confusion.
Well.
Daily costless hearing, item number 7.
Yes. Have
Your
you filed an
Lordship,
affidavit, Mr.?
I was not in a position to prepare my affidavit, Your Lordship, and I got some instruction in this matter. Petitioner serial number has come to 17, earlier it is 47. And
When this name was referred?
so, Your Lordship, in this case, it is given the communication that department is taken with the ministry for lifting the ban, which is not yet been done.
When it was done?
This, as per communication, it's Your Lordship, one letter is the latest one is 18/8/2023 also, and earlier also. First letter, I think it is
Tell us the
given
date clearly, Mr. Devnath. Because date is quite vital here.
This started from this 17/9/2008 onward, I think.
No, when they named, see, this application was made in 2008. Now thereafter, your department was supposed to forward that name, isn't it?
So, Your Lordship,
When the
now-
notification was this thing for seeking revocation of that ban, what is the date of that notice, Mr.
My lord, that
Jha?
was
in 22.
that was, my lord, the ban was imposed on 11th March 2021, my lord. That is annexed to page 6 of
11th March 2021, the ban, lifting of ban,
Lifting of ban, it is given.
2021.
Still, it is pending, Your Lordship.
No, it is okay, there is okay.
So, the new list has been sent to me by mail, Your Lordship. This letter addressed to
Do
19/4.
you intend to file an affidavit?
So, Your Lordship, this the communication has come to me by letter, so this whether it will be worked with, Your Lordship. This communication has come to me addressed to the scientist here in Botanic Subcommittee.
Show us a copy. Give us a copy. What is the order passed by this court?
my lord, with regards to the filing of the affidavit by the respondent with regards to whether the list which they have annexed earlier, whether it is the same list which was sent to the ministry for lifting the ban or not.
Now, whether you have made a request for lifting ban, it is not there. You have enclosed a list. What do you have to do with the list?
This letter.
See what you say in paragraph 2 in BSI. A ban on compulsory appointment imposed since 1998 by Nodal Ministry. That is the MOIF and CC. However, BSI authority requested so and so for lifting up, revoking the ban on the compulsory appointment for BSI. Accordingly, correspondence given. When it was request was made.
Your Lordship,
Is it not that you are trying to avoid the query?
Your Lordship, the next page, Your Lordship.
Yes.
This is a reference, Your Lordship. I believe, Your Lordship, in reference number 1 is there 17/9/2008 onward.
This is? Mr. Jamnath, you file an affidavit. Clarify it. Now, some persons who have filed application in 1998, they are also there in the list. Same position, I think, Mr. Jha, you have pointed out.
Is it, my lord?
Now, will you give somebody appointment on compassionate ground after they cross the age of superannuation?
So, Your Lordship, this now has been removed.
See the first one. His date of application is 1998. How many years have gone by now? 26 years have gone by now. Now, what is the age of that person? And then 2000, 2001.
1950, the age of that person is 1951.
1950.
50.
Date of birth.
Mal.
So he is 70, more than 70 years. So we will take him into service. File an affidavit, Mr. Kindly clarify. Please, this court has given this to keep it in your mind. This will not be reflected here in the order, but then keep it in your mind and you just clarify. Mr. Jha, let him file an affidavit. Mr. R. Devnath. CGC. You are CGC, isn't it?
Yes, Your
Waiting for the respondent submits that he has received necessary instructions in the matter. And prays for some time for filing an affidavit. It complies with order dated 14/2/2024 of this court. So, Mr. Jha, appearing with the petition, there is no objection. Prayer allowed. The respondent is granted further 2 weeks' time to file the affidavit. File the requisite affidavit. You want this to be retained, or I think you keep it, because you may say something else in this affidavit, so you let it remain with you. It will remain as privileged communication.
This just I got the communication today itself by mail.
It's okay, just read, go through, apply your mind, and then you place it. Sometimes it may happen that you place something, it may land up you in more trouble. Though we do not know how much the claim of the petitioner can be entertained at this stage.
No, but when court
At this stage.
no, Your
But
Lordship,
then at least you would like to see what department has done.
no, Your Lordship, in this matter, so just I put due to this, Your Lordship, this communication reached to me, and that by mail I get yesterday evening. So I feel that when a communication is there, I should go to
And
them.
you may perhaps have to type out also. These are all not legible. You may have to type out these letters if you want to annex it. You may have to type it out. Things are not very clear. Or you obtain clear copies. Yes.
Item number 11.
Why it has come again before this?
My lord, advocating is
Yes, Mr. Kumai, why it is again before this bench?
Yeah, this should have gone to, it was before the Honorable Chief Justice, my lord.
Then again, why it has come back?
We
I
were
have
also
no
very
idea.
surprised when we saw it in the cause list.
Anyway, service matter. This is
Service matter. Of course, there is no order of the Honorable Chief Justice. I think only because His Lordship is not holding court.
Notice, notification that all the matters pertaining to. There's a notification.
Okay.
That all the matters will be. till
Again,
the-
there is a change in, I think, modification of the earlier roster.
Yes, sir. There's a notification.
Anyway. All right. Yes. What is the case about?
This is regarding promotion and supersession.
Promotion
Promotion and supersession.
by association.
By
The employee, these are the employees
Yes,
of
yes.
the association, my lord.
Promotion of individuals, isn't it?
Yes, yes.
Not one particular individual.
No, no,
Promotion
no.
of all the
All the
members.
members. But it is like this.
There is no challenge to the maintainability of the case on the ground how association can come in or no.
I have challenged, my lord. I have questioned. I have questioned the
It is not
maintainability of
filed
the
in the nature of
expedition.
a PIL. Though
Yes, sorry, association cannot.
association
Sorry, some
and a case of promotion be advantageous. Okay. So, Mr. Kumar, are you challenging the maintainability of this petition?
Yes, my lord. I have challenged. I have said so in my
Then
counter
we'll have to
affidavit.
hear
also.
him fast before you come to the merit of the matter. Decide it on it. Mr. Kumar,
Will it be taken up today, my lord?
Then
On maintainability, will it be taken up today?
it's up to them. It's up to you. It's up to you.
So, my lord, if the
Your lordship may have it next week. Your lordship has maintainability issue. Your lordship may have it next week, my lord. I will place the judgment also and authorities also, and then I will give the advance copies to my learned.
Well,
So after a week we'll have it. If there is a
After a
question,
week,
if I can give
there is
just
there is a plea of maintainability. Is it there?
my lord,
sir?
if I may just give a little of the background, my lord. Little slightly, my lord, on the factual aspects.
Say rightly or wrongly, if there is an issue of maintainability of this petition, is it not regarded that that should be hard fast? You can give your background when you give a reply to his submission of maintainability.
All right.
You will not be
Yes, my
defined
lord.
any
Let me
opportunity.
take it up next week.
It should not be
My lord,
taken.
next, my lord, it may come up after the 10th, my lord. Till the 10th, I am not available.
If you parties agree, Mr. Kumar,
Yes, I have no.
is a request by senior counsel to have it after 10th.
Yes, yeah. I have to go by request of my learned senior counsel.
See,
Thank you so much.
you will go by whatever you say, except the question of maintainability. Okay, then we'll just say on the joint request to the parties.
Yes, my lord.
Okay, on the joint request to the parties, this is met after 3 weeks.
After the 10th.
After 3 weeks, it will 3 weeks.
After
from
3
now.
weeks.
After 3 weeks.
All right.
Nothing.